We're going to start in just a minute. I am calling to order this meeting of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Tuesday, November 15th, 2022. The time is 12:35 in the afternoon. This meeting is being conducted in the Council Chambers, room 500 of the John A. Wilson Building, but is also being broadcast live via the Zoom video conference broadcast platform, Council Channel 13, and is also available on the DC Council website, which is www.dccouncil.gov. There are, I believe, 5 members who are participating virtually, and there are at least 6 members present in the chamber. We begin our meetings by calling the roll to determine whether we have a quorum. Mr. Cash, would you call the roll?
Chairman Mendelson.
Present.
Councilmember Alley. Here. Councilmember Bonds.
Here.
Councilmember Che.
Here.
Councilmember Gray.
Here.
Councilmember Henderson.
Here.
Councilmember Louis George.
Here.
Councilmember McDuffie.
Here.
Councilmember Nadeau.
Here.
Councilmember Pinto. Councilmember Pinto. Councilmember Silverman.
Present.
Councilmember Robert White.
Present.
Councilmember Trayon White.
Here.
Mr. Chairman, you have a quorum.
Thank you, Mr. Cash. We have the Secretary's report of committee filings. I'm going to recognize the Chair Pro Tem, Mr. McDuffie.
And thank you, Mr. Chairman. I will move to waive the reading of the Secretary's report.
It's been a motion to waive the reading of the Secretary's report. Is there discussion? By a voice vote on the motion to waive the reading of the report, all those in favor say aye.
Aye. Aye.
Are there any opposed? I don't hear anyone opposing. The motion is carried unanimously. We have the Secretary's log of introductions and referrals. I recognize the Chair Pro Tem.
And I will move to waive the reading of the Secretary's log of introductions and referrals.
Been a motion to waive the reading of the log. Is there discussion? By a voice vote, all those in favor say aye. Aye.
Aye.
Aye.
Are there any no votes? Hearing none, the motion carries unanimously. We have another number of items for markup in the Committee of the Whole. There's no objection. I'm going to move the 4 confirmations for students in the care of DC Coordinating Committee. I'm going to move them in block. They are PR 24-933, students in the care of DC Coordinating Committee, David Domenici, confirmation resolution of 2022. PR 24-934, students in the care of DC Coordinating Committee, Dr. Felicia Hayward, educational doctor, confirmation resolution of 2022. PR 24-935, students in the care of DC Coordinating Committee, Keisha Fitzhugh, confirmation resolution of 2022. And PR 24-938, students in the care of DC Coordinating Committee, Claire Blumenson, confirmation resolution of 2022. The Students in the Care of DC Coordinating Committee Act of 2018 created the Students in the Care of DC Coordinating Committee, which is a public body composed of engaged non-government residents and agency representatives to support planning, policymaking, program development, and budgeting for successful educational experiences and outcomes for students in the care of DC. The focus of the coordinating committee is on district residents under 25 years of age who are incarcerated or detained by, committed to, and under the custody of, or otherwise under the supervision of the Department of Youth Rehabilitation Services, the Court Services and Offender Supervision Agency, the Pretrial Services Agency for the District of Columbia, the Family Court Social Services Division, the Child and Family Services Agency, the Department of Corrections, or the Federal Bureau of Prisons. The coordinating committee develops strategies and policies that guide implementation of the district's policies and programs to improve educational outcomes for students in the care of the district. The coordinating committee consists of 25 voting members and 4 non-voting members representing key community stakeholder constituencies and certain district agency heads or their designees. 17 members are agency heads or their designees, 8 are non-governmental members appointed by the mayor and confirmed by the council, and 3 are other governmental members or their designees invited by the mayor to participate. The coordinating committee is to be headed by a non-voting director appointed by the mayor. PR 24-933 would confirm the mayor's nomination of Dr. Domenici to serve. Dr. Domenici earned a Juris Doctor from Stanford Law School in 1993 and a Bachelor of Science from the University of Michigan in 1986. He has been a district resident since 1992. He is a civil servant and an educator, having spent most of his adult life working in education with a focus on system-involved and at-risk teens. In 1997, Dr. Domenici co-founded the See Forever Foundation and the Maya Angelou Public Charter School, where he worked full-time until 2011. While at Maya Angelou, he served as executive director and principal. PR 24-934 would confirm the mayor's nomination of Dr. Felicia Hayward for appointment. Dr. Hayward earned a Doctor of Education in 2020 and a Master's of Education in 2014 from Bowie State University. She also has a Master of Arts in Special Education from Trinity University and a Bachelor of Arts in Political Science from Florida A&M. She started her career as a special education teacher in a level 5 special education school and has worked as a classroom teacher for almost 7 years before moving into administration. She currently serves as both the supervisor of the educational programs at the Department of Youth Rehabilitation Services and the Maya Angelou Public Charter School at the DC Jail. PR 24-935 would confirm the mayor's nomination of Keisha Fitzhugh for membership on the coordinating committee. Ms. Fitzhugh earned a Doctor of Education in 2020. I'm hesitating because this looks like it's a duplicative of the other resolution. I'll just say that she is experienced. And PR 24-938, the students in the care of DC Court, PR 24-938 would confirm the mayor's nomination of Clara Blumenson for appointment to the committee. Ms. Blumenson earned a Juris Doctor from the University of Virginia in 2011, has a master's in teaching from Pace University, a Bachelor of Arts from Wesleyan University. Ms. Blumenson currently serves as the Executive Director and co-founder of School Justice Project, a DC-based nonprofit organization that provides special education legal services to older court-involved students with disabilities. Upon graduating from law school, she received an Equal Justice Works Fellowship at the DC Public Defender Service and spent 2 years working inside the district's secure juvenile facility as a special education lawyer for incarcerated students ages 18 to 22. To continue, develop, and expand on this work, she co-founded and launched the School Justice Project in 2013. Each of these nominees has a commitment to the mission of the Students in Care of DC Committee and has a background in education and working in the area that this committee will cover. Assuming that these are approved, the committee recommends adoption of each of these resolutions. Without objection, I'm moving the prints and reports for both the prints and reports for all 4 of these resolutions, with leave for staff to make technical, conforming, and editorial changes. Is there discussion? We'll do one roll call vote. Mr. Cash, would you call the roll? The vote is on PRs 24-90, 933, 934, 935, and 938, both the reports and the prints with leave for staff.
Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Mr. Chairman, there are 13 yeses.
The motion to approve all four committee prints and reports is approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Once the reports are filed.
Mr. Deputy Budget Director, does the measure's fiscal impact statement for each comply with council requirements?
Yes, they do.
Without objection, these measures will be placed on the consent agenda for today's additional legislative meeting. The next item for markup is PR 24-928, entitled the Congress Heights Small Area Plan Approval Resolution of 2022. The purpose of this resolution is to approve the proposed Congress Heights Small Area Plan, which was prepared by the DC Office of Planning in furtherance of the comprehensive plan. The Congress Heights study area is located in Ward 8, is bounded by and includes St. Elizabeth's and Suitland Parkway to the north, Stanton Road to the east, Oxen Run Parkway south, Oxen Run Parkway and Atlantic Avenue to the south, and Interstate 295 to the west. And includes predominantly low to moderate density housing, 2 commercial centers, and a significant government and institutional uses. It also encompasses the historic St. Elizabeth's Hospital site consisting of federal agencies on the west campus and ongoing mixed-use redevelopment on the east campus. The Congress Heights Small Area Plan is organized based on 6 themes: housing diversity and affordability, civic facilities, economic development and opportunity, historic and cultural preservation, parks and the public realm, and transportation and access. Small area plans are required to be prepared by the mayor for select areas of the city that necessitate specific, locally targeted planning and land use analysis. For the Congress Heights Small Area Plan, the planning process, coordinated by the Office of Planning, included substantial public engagement beginning in June 2021. From June 2021 to May of 2022, a number of working groups, town halls, focus groups, community meetings, and workshops were held to develop the plan. In all, the planning process included 23 community events led by the Office of Planning, over 8,000 mailers sent out to residents, and a series of online engagements. The draft plan was released for public comment on June 7th, 2022, and the mayoral public hearing was held on July 27th, 2022. I want to emphasize that a small area plan is only an early step to envision changes to Congress Heights. This will be followed by a number of zoning commission and other planning processes that will provide additional input from the public. This plan starts that process, and thus, assuming this is approved, the committee recommends approval of 24-928. This resolution was introduced at the request of the mayor on September 16th, 2022. The measure is not acted upon by the council before November 28th. The resolution will be deemed approved. The committee of the whole held a public hearing, public roundtable on the measure on October 27th, 2022. The committee received no testimony or comments in opposition to the plan. Without objection, I move both the print and report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? Mr. Cash will call the roll. The vote is on both the print and report with leave for staff of PR 24-928.
Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 13 yeses.
The motion, which is both the print and report with leave for staff, is approved unanimously. The next, before I go to the next measure, Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next measure for markup is Bill 24-124, entitled the Washington Metropolitan Area Transit Authority Board of Directors Amendment Act of 2022. The purpose of this bill is to simplify and clarify the requirements for appointment and service on the Washington Metropolitan Area Transit Authority Board of Directors. Pursuant to the WMATA Compact, all district appointments to the WMATA Board are by the council. None are made by the mayor. The current law governing the appointment of WMATA board members is lengthy, complicated, and largely ignored. It specifies 12 criteria for appointment. It prohibits former employees. It sets term limits, and it establishes unnecessary reporting requirements. For instance, any lawyer would qualify, any banker, any businessman. So then what's the point? On the other hand, a non-professional housewife or house husband with a college degree who uses Metro daily, say to take his or her kids to school, would not qualify for appointment. The prohibition on former WMATA employees being appointed is an unnecessary impediment. Let the council judge whether the experience of a former employee is of value. As for term limits, current law establishes a maximum of 2 consecutive 4-year terms. But over the last decade, of over 15 appointments, only 1 has served longer than 4.5 years, and 12 have served less than 3 years each. The limit on terms may sound reasonable to some, but it has no effect given our experience. Moreover, if someone is really good, the council should want to maintain that expertise on the WMATA board, especially when that experience gives the district an edge over our regional counterparts on the board. Bill 24-124 also strikes reporting requirements that are unnecessary. Attendance data can be obtained from the WMATA board secretary and is probably more accurate than a member's report. Stating the reason why a member misses a meeting is unnecessary, and besides, alternates are required by Virginia law to miss every meeting unless required to fill in for a voting member. Any meaningful information that the council requires can be obtained through oversight, especially since for several years, the reports have not even been filed. Bill 24-124 simplifies and clarifies the requirements for appointment to the WMATA board. It helps the council find individuals for appointment based on relevant expertise, quote, demonstrated interest in public transportation and experience sufficient to represent the district well, unquote. Ultimately, the quality of appointments is up to the council, but this bill provides clear guidance, and therefore, assuming this is approved, the committee recommends council adoption of Bill 24-124 as amended by the committee print. This legislation was introduced by me on March 1st, 2021. The Committee of the Whole held a hearing on October 6, 2022. The committee has received no testimony or comments in opposition to the legislation. I do want to make an oral amendment to the print where it says on line 32, thereafter members shall be appointed by the council to serve or complete a 4-year term. It would say thereafter members shall be appointed or reappointed by the council to serve or complete a four-year term commencing on July 1st. So the oral amendment is to add the words "or reappointed." There's no objection. I'll move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion? The vote will be on both the print and report with leave for staff. Mr. Cash, would you call the roll?
Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Mr. Chairman, there are 13 yeses.
The print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next measure for markup is Bill 24-251, entitled the Contractor Indemnity and Subcontractor Prompt Payment Amendment Act of 2022. On May 19th of 2021, Bill 24-251 was introduced by Councilmembers Bonds, Nadeau, Pinto, and Che. The bill would prohibit an owner or contractor from requiring subcontractors to indemnify a contractor or owner for damages arising out of bodily injury or destruction of property caused by the contractor or owner's negligence. At the same time, Councilmembers Bonds, Nadeau, and Che introduced Bill 24-252, the Subcontractor Prompt Payment Amendment Act of 2021. Bill 24-252 would amend the Private Contractor and Subcontractor Prompt Payment Act of 2013 to prohibit a contractor from withholding payment to subcontractors for work performed and completed on one job to offset losses, damages, or payments on another. The committee print for Bill 24-251, what I am moving today, combines both of these bills. In contracts, there are generally three types of indemnity clauses: broad form, intermediate form, and limited form. Under a broad form clause, the subcontractor would hold harmless the contractor or owner for any damages, losses, etc., arising out of the subcontractor's work, regardless of who is at fault. Under an intermediate form indemnity clause, a subcontractor holds harmless the contractor or owner for the subcontractor's negligence, but may only be required to pay partial damages depending on how fault is determined and calculated. If, for instance, a contractor is 40% at fault for damage to a roof, the subcontractor would be responsible for paying 60% of the damages. Under a limited form indemnity clause, the subcontractor only holds harmless the contractor for the subcontractor's negligence. Currently, district law does not prohibit broad form indemnity clauses, which means a subcontractor may have to pay for damages, losses, or expenses caused solely by the general contractor or owner. Such clauses can lead to a subcontractor paying tens of thousands or hundreds of thousands of dollars for damages or losses they did not cause. This is an untenable situation. Bill 24-251, the committee print, would rectify this by prohibiting a contractor from requiring a subcontractor to hold harmless a contractor or owner for a contractor or owner's negligence. As of December 2021, 19 states prohibit broad form indemnity provisions in construction contracts. The committee print retains language from the introduced version, which ensures that the prohibition against broad form indemnity clauses in construction contracts would not affect the validity of insurance contracts or workers' compensation agreements. The print also retains language prohibiting contractors or owners from requiring subcontractors to purchase additional insurance coverage or including provisions in their insurance policies that would violate the prohibition against broad form indemnity clauses. In construction contracts between general contractors and subcontractors, there is generally a set-off clause that allows the general contractor to withhold payment or deduct charges for liability or costs that the contractor has incurred because of the subcontractor's action. Sometimes these set-off clauses allow the general contractor to withhold payment or deduct charges under the specific subcontract in question and, quote, any other agreement between the parties, unquote. For example, say a subcontractor has two contracts with a general contractor on the same project. One contract is for electrical work and the other is for plumbing. During the electrical work, the subcontractor caused damage to the property, costing the general contractor $3,000. With a broad set-off clause, the general contractor could deduct or withhold the $3,000 in payments to the subcontractor on the plumbing work, even though the costs to the general contractor were incurred under the contract for electrical work. District law does not currently prohibit this practice. The committee believes, assuming that we approve this, the committee believes the prohibition against broad set-off clauses is desirable and necessary to protect subcontractors from potential financial distress. As such, the print for Bill 24-251 includes a prohibition on these broad set-offs, but makes one substantive change. As introduced, the bill would prohibit broad set-off clauses in contracts after the effective date. The print amends this to a date certain of March 31st, 2023. Consistent with the date certain also in the print for prohibiting broad form indemnity clauses. The committee print for Bill 24-251 would protect thousands of subcontractors. I'll start over. The committee print for Bill 24-251 would protect thousands of subcontractors in the district who perform critical work in the construction industry. As such, assuming this is approved, the committee recommends the council approve the committee print for Bill 24-251, which, as I said at the outset, includes provisions from Bill 24-252. Those two bills were introduced on May 19th, 2021. The Committee of the Whole held a hearing on both bills on October 19th, 2022. I move, without objection, I'm going to move both the print and the report with leave for staff to make technical conforming and editorial changes. Is there discussion? The vote will be on both the print and report with leave for staff. All those, Mr. Cash, would you please call the roll?
Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Mr. Chairman, there are 13 yeses.
The motion to approve both the print and report with leave for staff is approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next measure for markup is Bill 24-301, Business and Entrepreneurship Support to Thrive Amendment Act of 2022. As introduced, Bill 24-301 would reduce the number of business license categories from more than 100 to 10. It would lower initial basic business license fees to $99. It would exempt from fees businesses with under $10,000 in revenue. Establish a progressive fee structure. This was as introduced for renewals. The print retains the print, which is what we'll be voting on, retains several changes made by the introduced version of the bill, including adding notice language for the licensing of theaters, cinemas, skating rinks, etc. To DC Code 1-309.10, which I believe is the ANC law. It shifts language on the collection, storage, and processing of waste tires from Title 47 to Title 8. It shifts language on the suspension or revocation of licenses for illegal criminal activity from Title 47 to Title 42. It repeals numerous sections of Chapter 28 of Title 47. It shifts definitions and language on body art and body art establishments. I believe that's the same as tattoo parlors. From one section to another in Title 47, and it shifts and slightly amends language on for hire vehicle operator requirements from Title 47 to Title 50, which deals with traffic. The committee print makes several substantive changes to the introduced version based on discussions held by a working group that included council staff, agency staff, and external stakeholders. The print increases the number of business license categories from 10 to 11. So earlier I said is introduced, reduced it from over 100 to 10, so now it would be 11. But also provides a statutory definition for each of the 11 categories. The print would allow the Department of Licensing and Consumer Protection to create and revise business license endorsement categories through rulemaking, but prohibits the agency from charging an additional fee for an endorsement. So while this lowers the number to 11 categories, the department would have the flexibility to add a few. I don't have the number in front of me, but add a few license categories. The print creates a flat fee of $49 for 6-month licenses and renewals and $99 for initial 2-year licenses and renewals. The committee print requires the department to issue a notice of an impending license expiration to the licensee no later than 60 days prior to the expiration date, and reduces late fees for lapsed or expired business licenses. The print slightly amends existing language in the code regarding the establishment of the basic business license fund. And the print amends provisions in Title 48 of the code related to the closure of food establishments due to a lapsed or expired basic business license. The district's current business licensing laws and regulations are burdensome, confusing, and outdated. Right now, a resident looking to start a business must choose between over 100 license categories with a range of fees. Many of these license categories have been in the code since the early 1900s, and the fees for each license are often prohibitive and unrelated to the administrative burden of the department issuing the license. To modernize and streamline our business licensing law, Bill 24301, the committee print, significantly narrows the number of license categories, reduces licensing fees across the board, and removes or updates outdated and unnecessary provisions. All of this will make it significantly easier for residents to start and maintain a business in the District of Columbia, benefiting families, communities, and the district as a whole. The committee report includes a table that, if I can find it. For example, a barbershop license currently costs $190 and the new fee would be $99. On the other hand, a restaurant with 51 to 100 seats currently costs $844 and would be reduced to $99. A one-family rental is $198. The current fees are all over the place, and this brings it down to $99. The committee of the whole, the bill was introduced by Councilmember Brooke Pinto and co-introduced with Councilmembers Nadeau, McDuffie, and myself on July 12th, 2021. The committee of the whole held a public hearing on February 7th, 2022. I move the There's no objection. Now move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion? Councilmember Pinto.
Thank you so much, Mr. Chairman, for your comments and all of your work on this bill and moving it today. I introduced the Business and Entrepreneurship Support to Thrive Amendment Act of 2022, otherwise known as the BEST Act. Thank you to my Chief of Staff, Genevieve Hulick, for coming up with that name. To streamline the business licensing and renewal process so that it's easier to open and operate a business in Washington, D.C. We should be the best place in the region to be in business, especially now as we focus on our recovery. I'm thrilled that we're moving this bill today out of committee and taking the first vote at our legislative meeting. I also want to thank Kevin Ragey, the entire team at IJ, Ella Hansen on my team, Blaine Stum on your team, and you, Mr. Chairman, for your partnership on this important bill. Starting a small business in the district should be straightforward, efficient, and cost-effective. But the reality is that current licensing requirements are so convoluted that they discourage aspiring entrepreneurs and make it difficult for DCRA, now DLCP, to enforce the law. There are currently over 100 licensing categories and the possibility of additional endorsements, each with accompanying fees. While businesses with more resources can hire lawyers to help them navigate this process and can more easily afford the various fees, many small business owners are left to figure this process out on their own. This is time-consuming, costly, and out of step with our city's values of promoting equitable business opportunities for all. The BEST Act reduces the over 100 licensing categories to only 11, eliminates endorsements, and reduces basic business license fees to $49 for a 6-month license and $99 for a 2-year license. The bill also waives licensing fees for businesses with under $10,000 a year in annual revenue. Small businesses are the engine for our city's economic recovery and the COVID-19 pandemic, and they play a critical role in shaping the culture of our neighborhoods and making Washington, D.C. such a great place to live. The BEST Act sends a clear message that our city values the contributions of our small business community and takes an important step forward in removing barriers that have made it difficult for women and people of color to own and operate businesses in the nation's capital in the past. Thank you very much, Mr. Chairman, and I look forward to first vote on this bill today.
Thank you, Councilmember Pinto. Is there any further discussion? The motion is on both the print and report for Bill 24-301. Mr. Cash, would you call the roll?
Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print and report with leave for staff are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is. Nope, I'm sorry. Once the report is filed.
Almost got by. Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
I will note it's subject to, it will be subject to appropriation. The fiscal impact
Yes.
is something like $8 million a year.
Yeah,
Um,
over the 4-year plan, $29.5 million.
We could just stick with the 1-year cost, but yes, thank you. No, that is correct. Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next item on the agenda is Bill 24-570. I'm not moving that today. we were informed late last week that the Office of Revenue Analysis would not be able to complete the fiscal impact statement until, I believe, November 29th. So this will come up on December 6th. And if any member wants to talk to me about the bill, please reach out, because I want to make sure that members are comfortable with it. The next item is Bill 24-665, which is entitled Access to Advanced Placement Exams Amendment Act of 2022. This bill would require DCPS to allow students participating in a homeschool program to sit for an advanced placement exam or exams at the school that the student could attend matter of right, or a reasonable alternate location when the students or at a reasonable alternate location when the students of right school will not be offering that particular AP exam. The advanced placement exam, which is administered by the College Board, enables willing and academically prepared students to pursue college-level studies while still in high school. The program consists of college-level courses developed by the AP program that high schools can choose to offer, and corresponding exams that are administered once a year. Each year, the District of Columbia Public Schools offers at least 8 AP courses at each of its comprehensive and application high schools, with at least 1 course in each of the 4 core subjects. If students take the AP exam and pass, the college university they enroll in may grant them course credits. All students enrolled in DCPS schools that offer AP courses are eligible to take the exams. Currently, students participating in a homeschool program in the district do not have a simple way to sit for advanced placement exams, because homeschool students, by definition, are not enrolled in a DCPS school. Bill 24-665, the committee print requires OSSI and DCPS to make available on its website information on how non-enrollees may register for and pay for exams. So these homeschool students would be able to take the exams and would pay to the district government, DC treasurer. And this bill facilitates that. The bill was introduced by Councilmember Che and myself on February 16th, 2022. And the Committee of the Whole held a public hearing on the bill on September 27th, 2022. Without objection, I'm going to move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion? Councilmember Henderson.
Thank you, Mr. Chairman. I brought this up during the breakfast. I had 2 questions just in terms of administrative, how this would work. I have no opposition. I just want to be clear. And you said you needed to check with your staff. So the first was around, this would be a reimbursement, I guess, to the district government in terms of the cost, given that schools pay the College Board upfront.
I believe that's correct.
Okay. The second question I had was around, I guess we'll call it certification that a homeschool student is actually eligible to take the test because they took the course. Whose responsibility is it to check that?
My understanding is that would be OSSI.
Okay.
So currently, in order for a student where we have compulsory education in the city, for a student to be homeschooled, the student or the parent or the student has to be enrolled through or with the knowledge of and approved by OSSI.
Right.
So OSSI already knows of the student, and OSSI would be able to certify that the student's taken the AP class or is taking the AP class. So that's how the certification would happen.
Okay, thank you.
I will add, I don't think this is in the report. We think that the number of students each year would be in the single digits. We're not talking about very many students, but we are talking about an access to AP exams that ought to exist. Is there further questions or discussion? We have, the motion is for both the print and report with leave for staff to make technical conforming and editorial changes, and this is Bill 24-665. Mr. Cash, would you call the roll?
Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Mr. Chairman, there are 13 yeses.
The motion, which is both the print and report, is approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next measure for markup is Bill 24-939, entitled Repeal of Outdated and Unnecessary Audit Mandates Amendment Act of 2022. The purpose of this legislation is to repeal outdated or unnecessary mandates for audits and other reports required of the Office of the District of Columbia Auditor. The council last repealed a number of audit mandates in similar legislation in 2016. Notwithstanding this legislation, the auditor's broad authority to audit and investigate remains unaffected. And I'll probably say that 2 more times. By repealing these statutory audits, the auditor will have more capacity to perform useful oversight, which will benefit both the council and the public. The modification or repeal of any mandate does not affect the auditor's broad authority to examine or audit any agency or program in the district. The report itemized, or I shouldn't say itemized, details each of the areas within which these mandatory or statutory audits are being repealed. I do want to note that in the report, on page 3, there are 2 paragraphs dealing with contractor records. I should say subsections dealing with government contractor records. The second one is a mistake. What the committee print does is it does expand the auditor and inspector general's authority to access the books and records of district government contractors or subcontractors for all contracts, but it does not change the current law with regard to how long records must be maintained. This legislation was introduced by me on July 13th, 2022. The Committee of the Whole held a public hearing on October 27th, 2022. Committee received no testimony or comments in opposition to the legislation. Without objection, I move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion? The vote will be on PR 24-939, both the print and report with leave for staff. Mr. Cash, would you call the roll?
Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Mr. Chairman, there are 13 yeses.
The motion to approve both the print report with leave for staff is approved unanimously. Next item and last, Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next and last item for markup in the Committee of the Whole is Bill 24-666, entitled Soil Disclosures Modernization Amendment Act of 2022. This bill was sequentially referred first to the Committee on Transportation and the Environment and then to the Committee of the Whole. Councilmember Che, I didn't talk to you about this. Do you want to make any presentation here or leave it to me?
Go with it.
I'll go with it. Thank you. As introduced and marked up by the Committee on Transportation and the Environment, Bill 24-666 would require disclosure of the characteristics of the soil on a property in any contract to convey real estate in the district, but would update the source of this information to a more current and user-friendly soil survey map. That's as introduced. Let me give a little background very briefly. In 1977, the council approved DC Law 2-23, the Soil Erosion and Sedimentation Control Act of 1977. That law required that any contracts for the conveyance of real estate has to disclose the soil for that property. Since the passage of the law, real estate agents in the district must consult a soil survey map of the district published by the U.S. Department of Agriculture in 1976 and provide information on the characteristics of the soil of the property being purchased in a contract. As introduced and as marked up by the Committee on Transportation and the Environment, the bill would continue to require disclosure of soil characteristics in all real estate contracts, but would update the source for soil information to a more current, not a 1976 map, but a more current and web-based soil survey published by the United States Department of Agriculture's Natural Resources Conservation Service, published in 2019. While the web-based application makes it much easier for real estate agents and others in the industry to provide characteristics of soil and real estate contracts, the committee, assuming this is approved, is not convinced that this disclosure is necessary or useful. First, the committee could not find another jurisdiction with a similar requirement in the country. Second, the disclosure provisions in a typical real estate contract provide only the most basic information on the soil, nothing of significance. In the committee report, there's an example. I believe it's a property in Georgetown. It says, in the contract, the real estate contract, the characteristic of the soil of the property is described by the Soil Conservation Service, the United States Department of Agriculture, in the Soil Survey of the District of Columbia, published in 1976, and as shown in the soil maps of the District of Columbia, is urban land sassafras, Sholem. This really says nothing to a purchaser. It says nothing about the risk of soil erosion, the risk of flooding or ponding. It doesn't give any other information about risks posed by the soil on the property. Given these facts, the committee print for the Committee of the Whole repeals this disclosure requirement altogether. This bill was introduced by Councilmember Che in February 2022. The Committee on Transportation and the Environment held a public hearing on May 19th, 2022. It marked up this bill on October 20th, 2022. I move, without objection, I'll move both the print and report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? The vote will be on Bill 24-666, both the print and report with leave for staff. Mr. Cash, would you call the roll?
Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Mr. Chairman, there are 13 yeses.
The print and report with leave for staff are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed?
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. That completes markups in the committee as a whole. We have consideration of measures from other committees. The first two are from the Committee on Judiciary and Public Safety, chaired by Councilmember Charles Allen. And the first is Bill 24-203, Medical Examiner Records Privacy Amendment Act of 2022. Mr. Allen.
Thank you very much, Mr. Chairman. Bill 24-203, the Medical Examiner Records Privacy Amendment Act of 2022 was introduced on April 1st, 2021 by you with a request of Mayor Bowser. The bill was referred to the committee on April 6th, 2021, and the committee held a hearing on it on May 3rd, 2021. It was approved unanimously at the committee's additional meeting on November 3rd, 2022. As introduced, Bill 24-203 would have made all records generated or maintained by the Office of the Chief Medical Examiner, or OCME, confidential and exempt from disclosure under the district's Freedom of Information Act. It would have allowed next of kin and those seeking an external examination or autopsy report for legal proceedings to request access to the report directly from OCME, but all other persons would have been required to file a lawsuit in the Superior Court and then demonstrate a compelling interest that outweighs the decedent's family's privacy interests. Under current law, any person with a, quote, legitimate interest may have access to OCME case files and records. This term is admittedly vague and results in litigation. However, the introduced version of the bill goes too far by exempting all OCME case files and records from FOIA. The committee print finds a middle ground by respecting decedents and their families, discouraging voyeurs, but also accounting for the public interest. First, the committee print explicitly clarifies that external examination or autopsy reports are public records under the district's FOIA laws with respect to certain information. This change reflects the recognition that there will be instances where the public's need to know about the circumstances of an individual's death outweighs the privacy interests of the decedent families. One needs to look no further than the events of January 6th to appreciate this. The public's need to know can be great, and access to information can be critical in making sure the events of a day are accurately recounted. Second, the committee print allows for certain individuals to request an external examination or autopsy report directly from OCME without having to utilize the Freedom of Information Act, including next of kin, the executor of the decedent's estate, or insurance company. And third, recognizing that the release of photographs, videos, or images of a decedent's body taken during an autopsy can be inflammatory or personal if released publicly, the bill explicitly makes these items confidential and exempt from disclosure, except under very limited circumstances. OCME would be able to disseminate photographs, videos, or images for use or potential use in criminal or civil proceedings, or for use in medical or scientific education or research where the identity of the individual is confidential. Lastly, at the request of OCME, the bill makes a change as to how OCME handles property found on or in the custody of a decedent that aligns with best practices. OCME would be able to give a decedent's personal effects more quickly to next of kin and easily dispose of property found on or in the custody of the decedent that has no apparent value, like a gum wrapper, or poses a risk to public health or safety, like stained clothing the decedent was wearing. Thank you, Mr. Chairman, and I request this measure be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. Bill 24-951, Automatic Voter Registration Expansion Amendment Act of 2022. Councilmember Allen.
Thank you very much, Mr. Chairman. I introduced Bill 24-951, the Automatic Voter Registration Expansion Amendment Act of 2022 on July 14th, 2022. The committee to which the bill was referred on September 20th held a hearing on the bill on September 16th, and the committee voted unanimously in favor of the bill on November 3rd, 2022. This bill builds upon and expands the district's current automatic voter registration system, which was created by legislation introduced in 2015 and passed unanimously by the council in 2017. Our current AVR system is what is known as front end, in which residents are given the opportunity to opt out of being automatically registered to vote at the time of the transaction with the Department of Motor Vehicles. Since its implementation, the district's AVR system has helped dramatically increase voter registration, and it's streamlined the registration process. However, the growing consensus among many election experts is that what is known as back-end AVR is the superior model. Under back-end AVR, the prospective voter is given the opportunity to opt out after the agency transaction, usually through a mailer sent to their home address. Several leading jurisdictions in elections policy, including Colorado, Massachusetts, Nevada, and Oregon, currently use this model with great success. There are several benefits to back-end AVR. First, it's more effective at increasing registration than front-end AVR. And second, back-end AVR increases the accuracy of the voter rolls by automatically updating registered voters' addresses. Third, back-end AVR results in more representative electorate. Studies have shown the system captures more young voters, low-income voters, and non-white voters, as well as producing higher voter turnout overall. And fourth, back-end AVR has significant advantages in terms of security by presenting fewer opportunities for user and system errors. And lastly, back-end AVR is cost-saving. It decreases undeliverable mail to incorrect addresses, which is particularly important as the district transitions to all mail-in balloting. This bill transitions the district's AVR to a back-end system and creates a pre-approved for registration list for eligible unregistered voters. Under this model, prospective voters, information is automatically sent from the source agency, such as the DMV, to the Board of Elections for eligibility verification. That board places the eligible prospective voter on a list of residents who have met eligibility requirements but are not registered to vote in the pre-approved for registration list. Importantly, residents placed on this list aren't yet registered to vote. Instead, they're placed on the pre-approved for registration list, which is a list of eligible but unregistered voters and is separate from the voter roll. Within 14 calendar days after receipt of the prospective voters' registration information, the board is then required to mail a notification to the person that includes instructions on how to activate their voter registration. In other words, move their name off that pre-approved for registration list and onto the voter rolls. The mailer also gives the person the opportunity to affiliate with a political party and to request removal from the pre-approved for registration list if desired. Residents on that pre-approved registration list can activate their registration simply by showing up the polls or returning a mail-in ballot. There is no need for these voters to show proof of eligibility or to take additional steps other than actually voting. The print also includes several other noteworthy provisions to facilitate the expanded AVR system. First, it allows residents on the pre-approved for registration list to affiliate with a party when they appear at the polls on election day, an exception to current law. If I can have like just 30 more seconds, Mr. Chair.
Without objection.
The print also requires the board to mail all residents on the pre-approved registration list a mail-in ballot for general elections through which a resident can activate their registration by returning. And the print also expands the source agencies for AVR to include the Department of Healthcare Finance so that residents applying for medical assistance programs like Medicaid are automatically added to the pre-approved registration list if deemed eligible by the board. And lastly, the committee print includes an applicability date of January 1, 2025 to allow time for the board to plan for and implement this new system. Thank you, Mr. Chairman. I ask this measure to be added to the consent agenda for the legislative meeting to follow.
Thank you, Mr. Allen. Are there questions from members?
Mr. Chairman,
Councilmember Chang.
I put this question to Councilmember Allen before, but I just want to make sure it's out there for others. Some years ago, I did a major reform on voting, early voting and all of that. But one of the aspects of it was you can register on the same day as the election, same day registration. And I had asked Councilmember Allen, so I'll put the question again here for everyone else. This does not change same day registration. That still exists the way it is now, correct?
100% correct.
Thank you.
Thank you.
Further questions? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next three measures were reported out of the Committee on Housing and Executive Administration, chaired by Councilmember Anita Bonds. Each is before us with a proposed waiver of Committee of the Whole Rule 403B. That's because although they were filed timely to get on the agenda, they were filed a day late in terms of not having to waive Rule 403B. If there's no objection, I'll recognize Councilmember Bonds to move the waiver of Committee of the Whole Rule 403B for all three bills. Hearing no objection, Councilmember Bonds, do you want to make that motion?
Yes, thank you, Chairman. I ask that we waive the requirement at this time.
There's a motion to waive Committee of the Whole Rule 403B for the three bills. If there's no discussion on a voice vote, all those in favor of waiving the rule, say aye. Aye.
Aye.
Aye.
Aye.
Are there any no votes? The motion is approved. The waiver is granted. The first bill is Bill 24- 24 419, No Senior Hungry Omnibus Amendment Act of 2022. Councilmember Bonds.
Thank you, Chairman. Today I'm moving the No Senior Hungry Omnibus Amendment Act of 2022. This legislation was introduced by Councilmember Shea, along with Councilmembers Gray, Lewis, George, Henderson, Allen, Trayon White, Pinto, and myself on October 1, 2021. The committee held a public hearing on February 14th, 2022, and a markup on November 9th, 2022. The No Senior Hungry Omnibus Amendment Act of 2022 establishes a senior nutrition services communications plan and a senior food security plan to address senior food insecurity. Further, this legislation creates an interagency senior food security task force led by the Department on Aging and Community Living to regularly evaluate the district's programs and policies related to senior food insecurity. Other provisions of this legislation additionally amend the following acts. The Food Stamp Expansion Act of 2009 to require the Department of Human Services to expand access to the SNAP enrollment system and streamline submission processes. The Healthy Tots Act of 2014 to require the Office of State Superintendent of Education to provide outreach and technical assistance to adult daycare centers eligible for the Child and Adult Care Food Program, and the Department of Healthcare Finance Establishment Act of 2007 to require reimbursable services under the EPD Medicaid waiver to include home delivered meals, nutritional supplement, and medical nutrition therapy. Over the course of 4 years, this bill is projected to cost over $75 million and is reliant on the collaborative efforts between the Department on Aging and Community Living and the Department of Human Services, the Office of the State Superintendent on Education, and the Department of Healthcare Finance. I'm very pleased with the overwhelming support the bill has garnered from various organizations and individuals throughout the district, and urge my colleagues to support this bill today to take another step towards combating senior food insecurity in the district. Thank you, Mr. Chairman, and I move the bill.
Thank you, Councilmember Bonds. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Mr. Deputy Budget Director, does the measures fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. Bill 24-649, Elimination of Discrimination Against Women Amendment Act of 2022. This bill was reported sequentially first from the Committee on Government Operations and Facilities chaired by Councilmember Robert White, and then the Committee on Housing and Executive Administration chaired by Councilmember Bonds. Let me first ask Councilmember White, do you have anything to present on this, or do we start with Ms. Bonds?
I think we're starting with Ms. Bonds. If there's time, I would love to say a couple words.
Okay.
That's
Councilmember
great.
Bonds.
All right, thank you, Mr. Chairman. Today I'm moving the Elimination of Discrimination Against Women Amendment Act to ensure a safe and comfortable, stimulating, and fair work environment for women in district agencies. It amends the District of Columbia Commission for Women Act of 1978 to include additional requirements for identifying and combating gender discrimination. The District of Columbia Commission for Women Act of 1978 was crafted with the goal of supporting and bolstering programs that have an emphasis on evaluating and improving the status of women in DC. In 1979, short after the District of Columbia Commission for Women Act of 1978 was established, the United Nations adopted the Convention on the Elimination of All Forms of Discrimination Against Women. This proposal eliminates what constitutes discrimination against women and establishes an active Action Plan. Bill 24649 builds on the requirements and basic tenets stated in the United Nations Action Plan. The committee added a reference to section 102 12A of the Human Rights Act of 1977 to define the term gender identity or expression to be a gender-related identity, appearance, expression, or behavior of an individual, regardless of the individual's assigned sex at birth. My committee added the term gender identity or expression in the language of the required data to be reported in a gender analysis to ensure that all data collected of individuals' gender identity or expression will be protected from disclosure. The bill requires all district agencies to designate a liaison to the Commission for Women and to conduct a comprehensive gender analysis every 2 years. And it requires the Commission for Women to develop a 5-year citywide action plan for correcting any deficiencies identified by the gender analysis. The committee also added language to this section clarifying that the commission must submit the citywide action plan to the mayor and the council within a year of it becoming law and every 5 years thereafter. I'm moving forward this legislation today because it does important work in combating gender inequality. It uses the principles of the United Nations to identify and address the underlying causes and extensive repercussions of gender discrimination, requiring that individuals engage with coworkers respectfully.
Without objection.
Thank you. Holding government agencies and leaders accountable for fostering an inclusive work environment and providing employees with gender equity training are all critical steps in combating gender discrimination and building compassion and understanding. And this legislation will assist us in reaching our goal of one day providing a work environment in which women can meaningfully, successfully, and equally participate and contribute. And thank you, Mr. Chairman, and now turn to my colleague, Councilmember White.
Thank you, Councilmember Bonds and Chairman Middleton. The Elimination of Discrimination Against Women Amendment Act is a significant step to achieving gender equity in the district. The reason I drafted this bill is to end discrimination against women in the district, particularly in district government agencies. This bill is grounded in the principles of equality and respect for human dignity found in the United Nations' Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. I introduced this bill in January of 2022 with the support of council members Che, McDuffie, Allen, Nadeau, Trayon White, Pinto, and Louis George. In June, we held a public hearing with the Committee on Housing and Executive Administration, to which the bill was sequentially referred. I'd like to thank Councilmember Bonds and the Committee on Housing for getting this bill to us today after my committee marked it up last month. I'd like to thank the United Nations Association for providing guidance to my committee on how to strengthen the bill's implementation. And I want to thank Lisa Wright with the Committee on Government Operations and Facilities for whom this was the first major bill she shepherded through the legislative process. A key element of the bill that I'd like to highlight is conducting a gender analysis for every DC government agency. I believe that gender analysis will help the district better understand the ways in which systems of inequality based on sex, race, gender identity, and other identities intersect to create unique dynamics and effects. The analyses would also illuminate the racial and gender inequalities for transgender people of color in DC. So I look forward to voting in favor of this bill. And Chairman, thank you for your indulgence.
Thank you. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is record complete?
Yes, it is.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
No objection, this measure will be placed on the consent agenda for today's additional legislative meeting. Next is Bill 24-996, Senior Nutrition, Health and Wellbeing Act of 2022. Councilmember Bonds.
Thank you, Chairman. Bill 24996, the Senior Nutrition, Health, and Wellbeing Act of 2022 was designed to ensure that the Department on Aging and Community Living has the guidance to successfully improve the quality of life for seniors in the district. This bill codifies various programs and services that the agency is tasked with and aims to improve delivery of services using collaborative and data-driven methods. The bill ensures that the seniors are aware and have access to the full range of services offered by the agency and the district. It requires the agency to distribute informational mailers, establish a community-led task group, and requires the agency to establish a wellness check program. The bill requires the agency to provide enrollment assistance, improve their referral processes, incorporate senior input, and collect and report certain data. It also requires the agency to provide training to home health aides regarding new dietary preparation and cultural competency. The Senior Nutrition, Health, and Wellbeing Act not only emphasizes the importance of senior nutrition and health, but also highlights the need to address the overall well-being of seniors. The bill comprehensively targets the biggest issues facing seniors in the district regarding nutrition, but also access to housing, issues of isolation, and situations of neglect. By addressing these issues, the bill makes it more feasible for seniors to age in place here in the district. I also intend to offer an amendment to this bill, which will make a minor change to one of the data collection and reporting requirements. Instead of requiring the agency to collect data on vacancies in assisted living and nursing home facilities at the time of each referral, the bill will now require the agency to collect a quarterly census of occupancy and vacancy rates. And this data will be reported annually in the agency's performance oversight report. I urge my colleagues to support this bill as amended and to support our seniors. Thank you, Chairman.
Thank you, Councilmember Bonds. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Mr. Deputy Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the non-consent agenda for today's additional legislative meeting. That's going to conclude the business for this meeting. The next legislative meeting, well, we will have an additional legislative meeting following this meeting, and I'm going to propose a roughly a 15-minute break between this meeting and the next meeting. Following today's additional legislative meeting, we will have a regular legislative meeting on Tuesday, December 6th. And there will be an additional committee of the whole meeting prior to, well, on December 6th as well, prior to the legislative meeting. With that, we will start the legislative meeting at 2:10. The time is now 1:53 p.m. and this meeting is adjourned. Members should be gathering in the council chambers. All right, we're keeping tabs. We're keeping it, starting a list of the members who aren't here yet. Madam Secretary,
here at 2:08.
Madam Secretary, are folks online present, do you know?
I'm
You.
snacking. Yes, Mr. Chairman.
Okay, and we've got the four in the chamber. We have a quorum. Of
Yes, you do.
course, on the other hand, we'll have to move to reconsider the consent agenda.
And you've got to take.
Yes. Madam Secretary, do you think we should begin?
Yes, Mr. Chairman.
Okay. We're going to start at 2:15.
Go away.
I'm calling to order this meeting. This is the 39th legislative meeting of Council Period 24 of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council. Today is November 15th, 2022. The time is 2:15 in the afternoon. This meeting is being conducted, I want to say, live in the Council Chambers, Room 500 of the John A. Wilson Building, but a number of members are participating virtually. The meeting is being broadcast live via the Zoom video conference broadcast platform. It's being broadcast live on Council Channel 13. I believe it's streaming on DC Council, the DC Council website, which is www.dccouncil.gov. We always begin our legislative meetings with a moment of silence, an opportunity for reflection. I would ask that everyone observe a moment of silence. Madam Secretary, would you call the roll?
Councilmember Allen,
Here.
Councilmember Bonds. Councilmember Bonds. Councilmember Che. Councilmember Che. Councilmember Gray.
Here.
Councilmember Henderson.
Here.
Councilmember Lewis George.
Here.
Councilmember McDuffie.
Here.
Chairman Mendelson.
Present.
Councilmember Nadeau.
Here.
Councilmember Pinto.
Present.
Councilmember Silverman. Councilmember Silverman. Councilmember Robert White.
Present.
Councilmember Trayon White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam Secretary. This is an additional meeting, so the logs were covered during the Committee of the Whole meeting. We have the consent agenda before us. Are there any changes to the consent agenda?
Mr. Chairman,
Councilmember Pinto.
can I move to remove item F3, Bill 24-1070, the Coronavirus Immunization of School Students Temporary Amendment Act of 2022 off the consent agenda, please?
Are you asking permission? No,
I'm
it's removed.
asking in a polite way if we can move it off.
It is removed. It's item
Thank you,
3 on page 4, Bill 24-1070. I am removing from the consent agenda Bill 24-570, Schools First in Budgeting Act of 2022. This bill was not moved in the Committee of the Whole, so it is not properly before us. Are there any other changes to the consent agenda? We have the consent agenda before us. There are two changes. On page 3, at the top of the page, number 4 is removed. And on page 4, item 3 under section F is removed from the consent agenda. It's non-consent. Hearing no other changes to the consent agenda. Madam Secretary, would you call the roll? The vote is on the consent agenda as revised.
Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Che. Councilmember Che. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman. Councilmember Silverman. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Mr. Chairman, there are 11 yeses and 2 absents.
Mr. Chairman, motion to reconsider so Councilmember Silverman can vote.
Since I haven't announced the vote, I believe it's still in order. Madam Secretary, Councilmember
Councilmember Silverman,
consent agenda. Consent agenda.
I got that.
Yes.
There's.
Madam Secretary, did you hear that?
no. Councilmember Silverman,
Yeah, I'm voting yes on the consent agenda.
thank you. Mr. Chairman, there are 12 yeses and 1 absent.
The consent agenda is approved unanimously. On page 4, item F3. Coronavirus immunization of school students, temporary amendment act of 2022. Councilmember Henderson, do you want to say so moved?
So moved, Mr. Chairman.
Is there discussion? Madam Secretary, would you call the roll? The votes on Bill 24-1070.
Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che. Councilmember Che. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Member McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Member Nadeau votes yes. Councilmember Pinto.
No.
Councilmember Pinto votes no. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Mr. Chairman, there are 11 yeses, 1 no, and 1 absent.
Can I,
Councilmember Che?
I'd like to vote no on that measure, please.
Okay. Councilmember Che votes no. Mr. Chairman, there are 11 yeses and 2 nos.
The bill is approved on final reading. We turn now to page 5. The non-consent agenda. The first measure is Bill 455. The Omnibus Athlete Agent and College Athlete Name, Image, or Likeness Amendment Act of 2022. I am I'm moving to postpone that to December 6th. The committee report's not been filed. There's no objection. It will be postponed to December 6th. Hearing no objection, is postponed. The next measure is Bill 24-416. The Revised Criminal Code Act of 2022. Councilmember Allen.
Thank you, Mr. Chairman. Since this has been pulled off the consent agenda for the purpose of considering amendments, let me just quickly summarize the Revised Criminal Code Act, which is a monumental piece of legislation that overhauls, modernizes, and reorganizes the district's entire criminal code. It is the culmination of almost 16 years of planning, more than 50 in-depth working sessions between stakeholders in the district's criminal justice system, 3 public DC Council hearings, countless community meetings, and almost 2 years worth of work in the committee. There has not been a comprehensive rewrite or reorganization of our criminal laws since 1901, more than 120 years ago. Since then, Congress and many different councils have created new crimes and tinkered with existing ones. But unlike many other states, the district has never comprehensively modernized its criminal code. As a result, our criminal laws are a mess. They have been ranked among the worst in the country. They lack clarity, completeness, and proportionality. They're the basis of a modern criminal code. Since 2006, an independent agency, the Criminal Code Reform Commission, and its predecessor, the Criminal Code Revision Project, has taken a comprehensive and informed look at the best practices across the country and within the district to draft a modernized criminal code removed from the day-to-day headlines, but still reflective of the unique social fabric of the district. The bill we have before us today is largely the work produced by the commission and is the product of countless meetings, hard collaboration and compromise, and thoughtful engagement by a wide range of stakeholders, all of which might disagree with a particular element of the total package, but unanimously recommended moving it forward nonetheless. At the last meeting, I spoke at length about the numerous compromises the committee made to accommodate additional requests from the U.S. Attorney's Office and the Metropolitan Police Department. And at our last meeting, I thanked the many people that had done incredible work to help get us there. I'm not going to repeat their names, but I did neglect to single out Zach Walters from our Office of General Counsel. And so I want to make sure I thank him for his outstanding efforts as well. Today, we have the opportunity to take a monumental step toward a much improved criminal code, one that is more fair, more clear, more proportionate, and just as effective at both holding people that do harm accountable and keeping our city safe. So to that end, I'll be asking my colleagues to oppose any amendments, and I now move the measure, Mr. Chair.
Thank you, Councilmember Allen. We have the bill before us. The agenda does note that there is an amendment from Councilmember Pinto. I'll recognize Councilmember Pinto.
Thank you very much, Mr. Chairman. And thank you so much to my colleague, Councilmember Allen, for your huge amount of effort on this important bill. The Revised Criminal Code Act, or RCCA, as we refer to it, is a much needed and important comprehensive update to ensure that our criminal code is clear, fair, and proportional without undermining our important needs for public safety. The Criminal Code Reform Commission, or CCRC, was tasked with making recommendations to the council. And I have deep gratitude for their work and respect for their experience and their process. But ultimately, we as council members are tasked with representing our constituents and enacting the law. The vast majority of CCRC's recommendations are implemented in the RCCA, but some changes were rightfully made in the committee's markup. As a member of the Judiciary Committee, work closely with Chairman Allen to ensure that the RCCA reflects the needs of our communities and that our law enforcement officials have the tools they need to best serve district residents. I am very grateful for his collaboration on a number of issues raised by neighbors and our public safety partners. In response, the Judiciary Committee increased penalties beyond what the CCRC recommended for several offenses, including robbery, carjacking, burglary, and offensive physical contact, in recognition of the seriousness of these offenses. My amendment today makes a few similar changes to two other offenses out of a similar recognition of their seriousness, and to ensure that penalties are proportional and aligned with current sentencing practices in our city. Specifically, my amendment relates to two offense categories. First, to the offense of unauthorized possession of a firearm, which prohibits individuals previously involved in criminal activity or who are subject to certain court orders, including anti-stalking and civil protective orders, from possessing a firearm. My amendment treats a violation, second-degree possession, as a Class 8 felony, subject to a maximum allowable 4 years imprisonment. The current version of the RCCA limits sentences to 2 years, but my amendment would more clearly align with current sentencing practices. Importantly, nearly all recent sentences would fall within this Class 8 penalties, but 30% of current sentences are higher than the maximum penalties allowed under this current version of the RCCA. Additionally, violation by an individual previously convicted of a violent crime, first-degree possession, would be treated as a Class 7 felony, subject to a maximum of 8 years imprisonment. Mr. Chairman, may I have some more time, please?
Without objection.
Thank you. I was speaking about violations by individuals previously convicted of violent crimes. First-degree possession would be treated as a Class 7 felony, subject to a maximum of 8 years imprisonment rather than a Class 8 felony. Again, this would more clearly align with our current sentencing practices. Second, to the offenses of carrying a dangerous weapon, carrying prohibited firearms near schools, daycares, public pools, and other spaces that are heavily populated by young people is inherently dangerous and inherently reckless. This amendment ensures that the offense is treated commensurate to other offenses that involve similar criminal recklessness. My amendment treats this as a Class 7 felony, subject to a maximum of 8 years imprisonment, rather than a Class 8 felony, which has a maximum of 4 years. To maintain proportionality, because again, I completely agree that that was an incredibly important piece of this code revision, violations elsewhere in the community would be treated as a Class 8 felony, subject to a maximum of 4 years imprisonment, rather than a Class 9 felony. This would again conform with our current sentencing practices. Some have suggested that lower penalties are sufficient because multiple offenses may get stacked together. And yes, that is sometimes true, but often it is not. According to the DC Sentencing Commission, between October 2018 and June 2021, there are 340 cases where the defendant was sentenced for unlawful possession of a firearm. And in 70% of those cases, this was the single offense that was sentenced. These classifications acknowledge the toll of gun violence on our community and the ways in which guns create more possibility of harm and death at any moment. I want to emphasize that we do not want sentencing in our city to be reactionary, but we do have a responsibility to be responsive. I'm deeply concerned about the proliferation of firearms and the increase in gun violence in our communities over the last year, as I know all of our colleagues are. And this amendment ensures that judges retain discretion in penalizing the possession of firearms and that the penalties reflect the gravity and seriousness with which we as a community view them. These
Councilmember,
changes, last
You're
sentence.
2 minutes over your time.
Thank you, Mr. Chairman. I just want to note these changes are supported by the U.S. Attorney's Office, who prosecutes these cases, as well as Mayor Bowser, and I urge my colleagues to support this amendment today. Thank you very much.
Thank you, Councilmember. Councilmember Allen.
Thank you very much. I'm going to ask my colleagues to vote no on this amendment. And let's be very clear. It's not because I don't take gun possession seriously. I do. We all do. The revised criminal code before us also takes gun violence very, very seriously. And while we are all concerned about the prevalence of firearms in our city, the persistent levels of violence across communities, and the inherent dangers of merely possessing a firearm, even if it's never used, I want to remind everyone, sound criminal laws embrace nuance. They do not obliterate it. The amendment before us fundamentally misunderstands how provisions in the revised code work in concert to create a well-ordered, proportional system of punishment. It ignores and fails to appreciate the way the RCCA already accounts for how multiple offenses address illegal firearm possession, and that sentences for each of those offenses can be set to run consecutively, so they extend well beyond a penalty for just one offense alone. And it fails to understand and doesn't explain how various criminal penalty enhancements available under the RCCA can also increase the penalties to better match the seriousness of the offense. There are penalties for anyone found in possession who has a record that will add years to their charge. Additional charges for carrying a ghost gun, charges for carrying an extended clip or a bump stock or any other modification. There are enhancements for committing crimes or possessing a firearm while on pretrial release. Simply put, trying to tell folks that the RCCA doesn't treat gun crime seriously is untrue. The amendment before us would double the penalties for carrying a dangerous weapon across the board, expanding the law for all offenses in an attempt to carve out a small minority of cases that have received a higher penalty than what is authorized under the RCCA. Many of those cases already involve more serious crimes in the first place and have additional charges. I'll revisit those numbers during later debate. But this amendment and its underlying rationale ignores that the worst of cases are often accompanied by convictions and sentencing for other violent offenses, which would also be available under the RCCA before us. My bigger issue with this amendment is that it represents the kind of legislating by headline that got our criminal code into such a mess in the first place. This amendment is not based on any data or evidence that it would improve safety. It centers the law on outliers, and it flies in the face of the lessons that we should have learned. In this amendment, we will be making the same mistakes as councils before us. Few jurisdictions actually decided in one fell swoop to create a system of mass incarceration. It's death by 1,000 cuts as elected officials sought to have an answer for a very complicated and serious problem. It starts with what feels like a small decision or a tiny amendment that eventually warp our criminal justice system into the contorted mess that it is today. The fact that we're debating this on the very day we're taking a final vote to clean up the mess that made over the last 120 years should not be lost on anyone. We could spend more time figuring out why so many crimes are unsolved. Mr. Chairman, if I can also have an additional minute or two.
Without objection.
Thank you. We could spend more time figuring out why so many crimes are unsolved, or why people who know more about those unsolved crimes don't come forward, or why people in areas of the district plagued by gun violence might feel the need to even arm themselves, even when it could cost them years of their life. But that's complicated. It's hard, it's uncomfortable, and it's messy. So instead, we turn up the dial on penalties and we hope that we'll solve the problem. Maybe this will be the time, against all evidence, that the punitive policies will work. It's what happens when we avoid doing what the data suggests, what the science tells us, and what our own experience has proven. And let's just talk about the research quickly. While I could pull the same conclusion from any number of sources, I'll use what I found from the National Institute of Justice, which is the research, development, and evaluation agency of the United States Department of Justice, the same Department of Justice that employs the U.S. Attorney's Office. The NIJ has found that the severity of punishment, that is the length of sentence, is not what makes that punishment an effective deterrence. Rather, what actually creates a deterrent effect is the certainty of punishment, the likelihood an offender will be caught, and the swiftness of the punishment. This is a fundamental principle of criminology. Accountability matters, obviously. No council member up here believes otherwise, no matter how they vote today. But we need to recognize the difference between accountability and when increased penalties have diminished returns in deterring new crimes while they create new public safety challenges downstream. And let's not forget, we're talking about penalties for possessing a firearm, not actually using it. We're talking about cases in which the gun was not used in the crime. No one believes we should tolerate or ignore illegal gun ownership. Obviously, access to a firearm is a necessary ingredient to ultimately committing a gun crime. What I'm saying is that proportionality requires that we acknowledge that gun possession without the use of that gun is not as dangerous or harmful as when that gun is used to frighten, threaten, hurt, or God forbid, kill someone. That's a fundamental principle of the RCCA, that penalties should increase based on the harm committed, which they do to match closely with the sentences that are handed out today. I'll close with this. The rise in gun violence and other crimes we've endured for the last few years are taking place under our current criminal code with its higher maximum penalties. For supporters of this amendment, I hear you saying that we need to raise penalties to meet this moment, to send a message. But I asked to show the work. Where's the evidence that this time it'll work? At some point, this council has to reckon with what it means to have one of the highest incarceration rates per capita in the free world and yet endure this kind of violence. The Criminal Code Reform Commission did the hard work to wrestle with this and produce the recommendations by taking their time, digging into the research, and separating what we think works from what actually works. So I encourage us not to take a step backwards now because it's neither true nor accurate to tell the public anything other than the truth, which is the RCCA before us seriously, significantly, and proportionally creates accountability for gun crimes. Thank you, Mr. Chair.
Thank you,
Chair.
Councilmember Allen. Councilmember Fay.
Thank you, Mr. Chairman. You know, as I said this morning at the breakfast, we're swimming in guns here in the District of Columbia and swimming in gun violence because of those guns. Residents are being shot, children being shot, people are being killed. And we need a multi-pronged effort to be sure to respond to it. But we would, be blind if we didn't recognize that how we treat people who run around with guns doesn't matter. I think it matters, and this is not the time to loosen penalties for gun possession. Yes, let's eliminate mandatory minimums, but let's not impose this artificial ceiling that will reduce the punishment for these gun offenses. Some say, well, it won't deter. Well, by itself, it's not going to take care of the problem. Of course not, but it may deter to some extent. And in any event, deterrence is not the whole story. There is punishment for behavior that's dangerous. And there's also messages, and I think they do matter. I think that, as I said, people want to be safe. They want to feel safe. It is not a good message from this council to say that we're going to reduce crimes involving guns. And especially that we should do it in the name of fastidiousness. Oh, yes, they worked a long time. Thank you very much. They put it all together. Thank you very much. But I don't think it should take away from this council's responsibility, or that we should be blind to our responsibility to adjust penalties in terms of the harms that they cause and the dangerousness that they may involve. So I'm going to support Councilmember Pinto's amendment. We don't have to swallow everything. I did swallow many things. In particular, I don't like the extension of the, second look provisions. But we have to have some standards, and we have to have some lines that we won't cross. I think this crosses one. Take away the minimum, mandatory minimum, but don't put these ceilings that will have the effect of reducing sentences for guns. Thank you.
I will speak, and I'm going to speak in opposition to the amendment. And I want to be clear that opposition to the amendment should not be confused with whether we want to punish illegal firearm possession. Rather, what's at issue here is what will actually improve our efforts to deter gun violence. If the amendment doesn't have an effect, then why do we need to support the amendment? I think I see two issues here. First, that there is an overemphasis in this discussion about the importance of sentencing. And second, that it misunderstands how this revised criminal code is constructed. First, with regard to sentencing, the research is clear. Sentencing has little or no deterrent effect. In fact, when I say it has little or no, that's really being diplomatic and kind. The research is that sentencing has no effect and no deterrent effect. Yes, we need to punish people. And yes, there's some people who need to be put away for a long, long time. But those are other purposes than deterrence. Swift and certain justice. The research shows the certainty of arrest and certainty of conviction, and the swiftness of that has a deterrent effect, but not sentencing. So we can argue about it, and we can argue about it all day, and it really doesn't make a difference in terms of reducing gun violence. Politicians often propose longer sentences as a way to fight crime, and it's the wrong approach. I also want to add that for most sentences for simple gun possession fall within what's in the bill unamended. The actual sentences will not be affected by this amendment. In other words, this amendment does very, very little. The second point about misunderstanding how this revised code is constructed. The RCCA proportionately increases penalties based on the dangerousness of firearm possession. If a person with a prior conviction for a crime of violence possesses a firearm in their home, the person is guilty of first-degree possession of a firearm by an unauthorized person. Carrying a firearm outside the home without a license, which presents a greater risk of harm compared to possessing the gun in the home, constitutes a separate offense. Second-degree carrying a dangerous weapon punishable. If the weapon is particularly dangerous, for example, if the firearm is a ghost gun, this constitutes yet another offense. The point being that the way the code is constructed, there's a layering of charges. Under the RCCA, these multiple offenses can apply in a single case, and judges have the discretion to order that the sentences be served consecutively. So under the situation I just described, the RCC authorizes up to 10 years of incarceration for possession of a firearm, not 2 years. This amendment looks at one level of offense and misses or ignores the layering of charges built into the revised code. So again, there's an overemphasis on the importance of sentencing. This amendment misunderstands how this revised code is constructed. And again, it's not about whether we want to be light on crime, because we don't. It's whether this will actually make a difference, and it won't. Further on the amendment, Councilmember Henderson.
Thank you, Mr. Chairman. I asked a couple of questions at the breakfast that I want to ask here on the record, because I think it helps in terms of the narrative or people's understanding of what we're doing here today. So Councilmember Allen, if you would so indulge. In terms of the bill overall, what is the applicability date?
The bill, when it was first introduced to us, the applicability date was going to be relatively quick, about a year. Hearing feedback from the courts, from a lot of stakeholders, we decided to set an applicability date that's about 3 years out so that we have time to be able to do the type of training, support, improvements across the whole system to be ready for it to be able to be implemented. So it's approximately 3 years.
Approximately 3 years. Okay. So I feel like we need to reiterate this to folks, especially in terms of this particular amendment. I think that we all are concerned in terms of the gun violence that we're seeing in our city. In particular, I have a particular concern about the gun violence that we're seeing from juveniles. And the criminal code that we're dealing with today doesn't deal with, number one, it doesn't deal with juveniles unless they are charged as an adult. And number two, any sentencing or penalty changes is not something that's going to go in effect tomorrow. So if a person who is committing crimes today, they're currently on trial today, we are dealing with the existing criminal code as it is. And so I've had a lot of people who've reached out to my office to say, how can you be reducing penalties in the middle of what we're going through? And I just want to underscore to folks that this is forward-looking, but also to the points that the chairman made earlier, and that you did also, Councilmember Allen, in terms of the proportional effects of layering here. In terms of, and I think there's another amendment that's pending, and that's a similar conversation I think we'll have in terms of what are penalty enhancements, what do those do, and then how does all of this play out in practice. We received a letter, because I have a little bit of time, so I'm going to keep going. We received a letter from the commission's executive director, Jinwoo Park, and I appreciate him sending this, and very detailed, but also, includes some footnotes and things like that as well. And in one of them, he references some of the data. So the DC Superior Court provided the CCRC with data on all adult criminal sentences imposed from 2010 to 2019. According to this data, the median sentences for unlawful possession of a firearm was 3 years. Carrying a dangerous weapon was 1 year. And possession of a prohibited weapon was 3 months respectively. So I think that what we have before us I hope you guys can hear me. What we have before us is, I think, in line with what has been sentenced in the past. Thank you.
Thank you, Councilmember Anderson. There was some noise on the dais, which if members could try to control that. Further, Councilmember Lewis George, you wanted to be recognized?
Yes, thank you, Chairman. I want to pick up on this thread from some of my colleagues. I think there is no doubt that gun violence is having a devastating effect on our communities. I've gotten those late night calls letting me know about a shooting in the ward. I've been to the scene to comfort families and speak to neighbors. I have been to funerals for community members who should still be with us today. As a council member, I have approached this rewrite of our criminal code first and foremost from a lens of whether this will make our communities as a whole more safe. That's in addition to the critical considerations we have about making our laws more just, more equitable, more consistent, and more proportional, and more clear, which is also an important step we're making today by making it more clear. I cannot support this amendment because it will not make our communities any safer. But before becoming a council member, I served as an assistant attorney general in the district who regularly brought cases related to gun possession and gun violence in our city, from CPWLs to UFUAs to armed carjackings to carjackings. armed robberies. So I want to be clear about the facts related to this amendment as it relates to the law. I'll go with the first point that the chairman has already made, that first off, the data shows that higher maximums and longer prison sentences are ineffective at deterring crime and are therefore ineffective at preventing gun violence. The American Bar Association has released data on this numerous of times. For those of us who are barred in the District of Columbia and other jurisdictions, we know this. People thinking about committing a crime do not read our statutes and nickel and dime which offense they will commit based on the sentence for each charge. That's just not how this works. And because we know that it doesn't work, we should be more thoughtful about ramping up incarceration at a great cost to the public, i.e. tax dollars, and at a great cost to incarcerated individuals, victims, their families and their communities, which are all a part of our communities. Secondly, I think the most important part here, it is not true that the revised code would let individuals off lightly for gun possession. The revised code has an entire set of penalty enhancements and additional charges related to possession to hold people accountable for possessing guns in our community. To look at these two charges on their own is misleading, and as any prosecutor can tell you, does not reflect how these cases are realistically handled in courtrooms and in plea bargaining. We have separate charges if the weapon is a ghost gun, if the weapon is modified with a clip, if the weapon is carried outside the home. We also have if the weapon is carried by someone on a pretrial detention, and if the weapon is carried by someone who is a repeat offender. These separate charges, these enhancements already exist. Chairman, my time is almost up. Can I have an additional time, please?
30 seconds.
Thank you. Lawyers will now be able to more easily combine these offenses with our streamlined code to bring forward an appropriate charge. And then, and if an individual intends to use the weapon or actually uses weapon, there's another entire set of additional charges and penalty enhancements that are justifiably even more severe and result in longer sentences. And then there is, of course, the charge associated with the predicate offense, the primary crime that was committed, which is how we uncover and recover most of the legal guns in our city. And so we're falling for alarmist talking points when the reality is, as a prosecutor, is that in almost every case we come across, individuals are being charged for a set of offenses and penalty enhancements that add up to a sentence that's much longer than any offense looked at in the vacuum. And so, though I have very serious reservations about the over-reliance, we need to tell the truth about the revised code and what it actually looks like in courtrooms here in the District of Columbia. Thank you.
Thank you. I'm hesitating to cut folks off, but I let the maker of the amendment and the chair of the committee go 2 minutes over, and everybody else has been about 30 seconds over. So who else on first round? Councilmember
Mr. Chairman,
McDuffie. Mr. McDuffie.
I'm going to keep my remarks brief because I really think my colleagues have done a really thorough job of covering the points, and I don't want to be redundant to what Chairman of the Judiciary Committee has already stated, or what you have stated, Chairman. I will say, and just to amplify a point that Janice Lewis George has made, as much as I wish and perhaps others think that people who are committing gun violence are actually looking at the penalties associated with possession of a firearm or any other penalty in our code, the reality is on the streets, they aren't. And so we should really be thoughtful about disabusing people of the notion that the amendment before us is going to make our city safer in any way. I don't believe that it would. And I appreciate the efforts to provide clarity following the amendments by the executive director of the Criminal Code Reform Commission, by the folks at the DC Justice Lab. I think it's important that people understand that we have a better code. We will have a better code once this is passed. And the concept of proportionality is absolutely essential to the work of the commission. But it's important for people to know that the criminal code before us is not lowering penalties. In fact, in many areas, it is raising penalties. And what the public should know about safety and the way that our criminal justice system works, and even the tools that the U.S. Attorney's Office has, in some cases, there are whole new offenses that are easier for the prosecution to prove. And I think that is something that we should be highlighting. I fully appreciate, as my colleagues have articulated, the crisis of gun violence that we're experiencing in the District of Columbia, as cities are across the country. But what we're doing with our revised criminal code is absolutely essential. The amendments before us are not. And therefore, I'm not going to support the amendment.
Thank you, Councilmember McDuffie.
Mr. Chairman.
On first round, Councilmember Robert White.
Thank you, Mr. Chairman. I appreciate that my colleagues have gone through the data points thoroughly, and so I don't want to spend time there. I would note, though, that the objection or the support for this amendment comes from the U.S. Attorney's Office, which is within the Department of Justice. The Department of Justice has for almost a decade acknowledged that longer sentences do not deter crime. The other perspective I want to share is a more human perspective. Growing up, I met a friend when I was in junior high school, and I shouldn't use his name, so I'll call him Sam. I was at an event actually at church with Sam, and I asked him why he was carrying a book bag. He said he had a gun. Now, this was an honor roll student who had a mother who dealt with addiction and a younger sister with special needs, but he couldn't get from his home to church without a gun to protect himself. Now, as I grew up, I realized that there were a lot more people like Sam. And we might, in our heads, think of anybody who's carrying a gun as a criminal. And I suggest a lot of people who carry guns are criminals and should be off the streets. But in the 80s and 90s, what we did to keep us safe was to develop blunt tools that not only swept up dangerous people and criminals, but also swept up people who I would say are in large part victims of failures from bodies like this one, people who need help from bodies like this one. So when we characterize people a certain way without understanding or having ever shared their lived realities by creating blunt tools, we hurt those people more. We are better than we were in the 80s and 90s because we have learned important lessons. What I'm suggesting to my colleagues and others who want to keep our city safe is that my friend Sam is not by a long shot an isolated case. There are people in our city who live like this, who don't want to live like this. On today's agenda is a report. It'll be, I think, the third report from the Criminal Justice Coordinating Council, from work that we have been doing in the background to study and examine the types of things that get young people in particular caught up in the juvenile system and the types of programs that help keep them out. Those are the types of investments that help keep us safe. There are some things that will get us good headlines. There were some things that will make us feel good about what we did, but there is collateral damage and we have to be conscious and careful about that. So I suggest that blunt tools are not the answer here. A balanced bill that the Judiciary Committee has developed with the right stakeholders is the right approach here. I will vote no to this amendment. I encourage my colleagues to vote no, not because the intent is wrong, but because the execution is misplaced. Thank you, Mr. Chairman.
Thank you, Councilmember. Second round, Councilmember Pinto, and then Jay.
Thank you, Mr. Chairman. And I want to thank all of my colleagues for your powerful points and statements. And thank you, Councilmember White, for sharing that story of your friend, Sam. And I think Sam is an exact perfect example of why we are getting rid of mandatory minimums. because there are facts and circumstances of cases that deserve to be heard by judges. Judges should be granted discretion, which is what I'm asking, to give judges the opportunity to use their discretion. I want to just address a couple other things that were raised. One, this amendment does not raise penalties. We have learned the lessons from our past. We're not raising penalties here. This is still lowering penalties. It's just raising the penalties in a more proportional way from the current version. Both versions, my amendment and the RCCA, both lower penalties for these offenses. Mine makes it more commensurate with current sentencing practices. I won't spend too much time going over all those numbers again, but wanted to make sure that was very clear. Second, I agree that proportionality is a huge concern, which is why this was not based off of headlines or some reactionary response to our current state of affairs in our city. It was based on a reading of the entire commission report and a look at all other classes in felony categories. When I look at class 8 felonies and see things like blackmail all the way to negligent homicide, that is quite a wide range, because again, these are allowable maximums permitted that I would argue and do argue that illegal possession of a firearm, when the facts and circumstances dictate, are commensurate with other class 8 felonies, which is why this amendment maintains the proportionality, which is so important to the entire code revision. And lastly, I just want to note comments about this is not going to solve gun problems in our city. Can I just have 20 more seconds?
30 seconds without objection.
Imprisonment is only one tool that we have to address safety. And we know that we have to continue to look for other innovative ways to increase alternatives to incarceration where appropriate, other investments for our young people, opportunities for jobs. All of these pieces are extremely important to me, to all of our colleagues, to our city, and we will continue working on those. No one is suggesting this amendment is going to solve all of our gun problems. But I do think it's really important as a city that prioritizes and values gun control to take these measures seriously and to make sure that they're commensurate with other felonies in the code.
Thank you,
Thank you.
Councilmember. Second round, any further? Councilmember Che.
Yes, just a response to some of the things that have been said, and Councilmember Pinto did some of this work. All of the things that are being pointed out, well, you think criminals, they look to the code and see what the penalties are before they do certain things. Well, then why did we look at carjacking? Do we think that people who carjack go to the code and look at it and say, I'm going to carjack today or not? No. So all of the things that are being said about this particular amendment could be said about other changes that were made from what was recommended by the commission. So I hardly find those things persuasive. And we have to stop saying that we're increasing the penalties. What we're saying is that you shouldn't lessen the penalties, or at least you should give judges the discretion to decide on what the penalty is within the range of what exists today. We're not increasing the penalties. And then the other point, we should stop characterizing people in a certain way. Sam needed a gun for his protection. Great. The law will allow adjustment for those purposes. This doesn't change anything like that. This doesn't characterize anybody in a certain way. But it does say we're not going to put an artificial ceiling that lessens punishment for gun possession in these certain areas. And as Councilmember Pinto said, as a response to a number of things others have said here, well, why don't we do this? And why don't we do that? And why don't we, what's that expression? We can walk and chew gum at the same time. This doesn't foreclose our looking at other methods to try to control guns in the district. I think this is a very sensible change to put us back in a position where we were and do away with mandatory minimums. So I hope people would look at this in the right light, and then I think they could support it. I support it. Thank you.
Thank you, Councilmember Che. Councilmember Allen.
Thank you, Mr. Chair. I appreciate the comments from so many colleagues. And I do want to remind, I guess, not just the council, but I think to the public, it can be very difficult to compare our current sentencing practices with what the RCCA provides. This debate's actually a good example of the shortcomings of our current law, because our criminal code relies on broad ranges for sentencing and vague definitions. So in practice, it can be hard to know the factors a judge made when handing down a sentence. There's a lack of consistency that I think frustrates everyone involved, actually. That is true for gun possession charges. One of the biggest benefits we will see from the RCCA will be greater transparency and consistency in sentencing. But it is important to dig through the data, and it is important how we talk about what this is or is not going to do within penalties. I will just go back through the sentencing statistics for the second degree carrying a dangerous weapon, which is part of what this proposed amendment is trying to speak to. Because I've heard it said that it's trying to capture the range of penalties that could be handed out. The sentence under the courts right now that exceeded the 2 years that would be authorized under the RCCA is in 7.2% of cases. Then though, you have to look at, because this is what you have to pull apart from what we have under current code and what we have under the RCCA. Now, some might say, well, it's only 7.2%, so the 93%, that's pretty consistent. All right, well, guess what? It's actually even more consistent. Because when you take a look at that, 84% of those that go above 2 years had accompanying other charges. But because of the lack of clarity in our code, you have to dig in deep to pull all this out. So once you pull that out, what you find is that only 1.1% of cases that had a conviction carrying a charge over the RCCA max had no other convictions in this case. So what the RCCA proposes without an amendment is 99% consistent with what the cases are and sentences being handed out. So I encourage my colleagues to vote against this amendment and support the underlying bill. Thank you, Mr. Chair.
Thank you. If there's no further discussion, are you asking to be recognized, Councilmember?
I
Silverman?
am, Mr. Chairman.
Councilmember Silverman?
So I was open-minded about this amendment, Mr. Chairman, but I will be voting against it. Let me just state the obvious. You know, we are struggling with gun violence in our city. And I hear my colleagues who are surrounding me, you know, and I think their intentions are good. We need to have a comprehensive and effective solution. But I asked the council member who moved this amendment, you know, and about a little bit more about the facts here, this amendment does not increase penalties. So if we're struggling now, we're going to remain struggling. And I guess I'll leave it at that. We need to come up with more than optics. Our city, our residents, our businesses want effective solutions, not optics. Thank you, Mr. Chairman.
Thank you, Councilmember. There's no further discussion. We'll have a voice vote on this. All
We
those,
have a roll call vote, Mr. Chairman.
Madam Secretary, would you call the roll, please? The vote is on the amendment.
Councilmember Che?
Yes.
Councilmember Che votes yes. Councilmember Gray?
Yes.
Councilmember Gray votes yes. Councilmember Henderson?
No.
Councilmember Henderson votes no. Councilmember Lewis George?
No.
Councilmember Lewis George votes no. Councilmember McDuffie?
No.
Councilmember McDuffie votes no. Chairman Mendelson?
No.
Chairman Mendelson votes no. Councilmember Nadeau?
No.
Councilmember Nadeau votes no. Councilmember Pinto?
Yes.
Councilmember Pinto votes yes. Councilmember Silverman?
No.
Councilmember Silverman votes no. Councilmember Robert White?
No.
Councilmember Robert White votes no. Councilmember Trayon White?
No.
Councilmember Trayon White votes no. Councilmember Allen?
No.
Councilmember Allen votes no. Councilmember Bonds?
No.
Councilmember Bonds votes no. Mr. Chairman, there are 3 yeses and 10 nos.
The amendment fails. Further on the bill,
Yes, Chairman.
Councilmember Trayon White.
Yes, I want to thank Councilmember Allen and staff the Committee on Judiciary and Public Safety, and all the residents, experts, and advocates who testified to put the Revised Criminal Code Act of 2022 before us today. I introduced an amendment, and some of you may have seen the circulated amendment today, and also the email by the DC Justice Lab and CJCC. As they indicated, the RCCA includes clear penalties for possession of high-powered weapons and accessories. As Mr. Park noted in the email, the RCCA allows for multiple offenses and penalty enhancements. I do not believe that this particular amendment, which creates a penalty of enhancement specifically for the use of high-powered firearms and high-capacity magazines on the commission of a crime, is a duplicate effort. This amendment specifically bumps up one class for the use of high-powered weapons during the commission of a crime. I'm going to withdraw this, but I wanted to speak to it even still for public record. This was nothing short of a monumental feat by those who organized the commission, the council members, to do a extensive work to go into this. My amendment today will raise the ceilings on the use of assault weapons, machine guns, and high-powered firearms. The penalty enhancement would also apply to the use for high-powered magazines, extended clips, in addition to allowing for more than 10 shots to be fired from a weapon during the commission of a crime. In addition to the provisions that are already in the RCCA around possessions, is for low, specifically for penalty enhancements with these extraordinary dangerous weapons in the commission of a crime. I've never in my life seen this amount of weaponry used in communities where kids live, where families live, where everyday residents sleep, eat, and play. In my history in DC, and I've been here when there was the murder capital and the crack epidemic as a young person in this city. I'm hearing rounds go off 30, 40, 60. I even went to a crime scene, was 100 plus rounds of bullet fragments on the ground at one crime scene. And that's concerning. We have to, I believe in a public health approach to public safety. And I believe we started on that journey in DC. We are way late, but nonetheless, we are pushing in that direction and made some leeway. But I feel for my fellow parents, our educators, our children, our workers in the community. And more importantly, I've never seen this many women shot in our city, right? Women and kids were strictly off limits. Not to say anyone should be shot for that matter, but the rules have changed. Again, I'm going to remove this amendment, but I did want to speak to, the weaponry of bullets being used in this committee. That's not, every time a bullet leaves that chamber, it lands somewhere. And we're seeing crime scenes where we have to call 3 to 6 ambulances to one crime scene to pick up victims off the ground. And we averaging about 2.5 people shot in DC a day. And it's simply out of control. And so I know this doesn't deter people from shooting, but we have to use methods like this. And I'm not talking about my amendment, but just look at our codes and our laws again, and also figure out ways we can do stuff on the front end to help people, deter people from a life of crime and violent incidents. So I want to thank you, Councilmember Allen, the committee, the advocates for introducing this bill, and I'm going to withdraw this today, but I want to.
Thank you, Councilmember White. Is there discussion on the amendment? Oh, did you move the amendment or Mr. White? He withdrew it? I misheard. Okay.
Yes, I withdrew the amendment, Chairman.
Thank you. Is there further on the bill? Councilmember Pinto.
Thank you, Mr. Chairman. I just want to again thank Councilmember Allen for all of his work on this bill and reiterate part of our discussion from the Judiciary Committee markup, which is that this bill not only is a century or more in the making of needed updates, but it really will do a lot to modernize, standardize our code, which will make things more consistent and fair, both for prosecution and for defense, the defense. And so I am still proud to support this bill. And I hear a lot of our colleagues' conversation from earlier about needed investments in new strategies to think about safety. And I just want to be clear to the public that I think that this bill is a really important step forward and does a lot of really good things for our criminal code. And so thank you, Mr. Allen, and thank you to all of the many stakeholders who have been involved in this process.
Thank you, Councilmember. Councilmember Henderson.
Thank you, Mr. Chairman. Again, I spoke a little bit about this at the breakfast, but I think it's important to put on the record, especially if some of our friends on the other end of Pennsylvania Avenue are listening. DC is in a very unique position, and I think all of us recognize that. And I said, and speaking about Councilmember Pinto's amendment, that the RCCA is forward-looking. And while there are some things that we can't expect or plan for, I think we have to do more work in terms of managing the judicial vacancies that we have, which I believe is now 14, which is about a quarter. And as more vacancies come online, I think the chief judges mentioned that we could be at a third of our court bench being vacant in 2023. So, Mr. President, if you're listening, to the chair of the Senate Judiciary Committee, to Majority Leader Schumer, I hope that we can get some of our judges who are currently pending confirmed. But I also think that it's going to be important for this body to be nimble. I am concerned about overwhelming the courts with some of the things that we have in the RCCA, and I appreciate that we have checkpoints as we bring back on the right to jury demandability in terms of misdemeanors. And so I hope that everyone is open to revisiting this if necessary. If our vacancy situation, which we are hamstrung on, but if our vacancy situation does not improve, and I think I made a mistake. I said chair of the Senate Judiciary Committee. I meant his GAC in terms of moving our judges. So I want to thank everyone who worked very hard on this and diligently on this. I do suggest that folks read the committee report, which I think is very thorough and gives a good explanation of why we're doing this. And some of the changes that were made in the committee print going forward. So thank you.
Thank you, Councilmember Henderson. Councilmember Louis George.
Thank you. Thank you, Chairman. I just want to thank and commend Councilmember Allen and everyone on his staff and the Judiciary Committee for their years of shepherding this monumental process of restructuring and improving our code. Your work here will go to make our city safer, because true safety is rooted in equity and transparency and in access to justice, the hallmarks of this code reform. As a former prosecutor, I need to say a special thank you for making the jobs of the defense prosecutors clearer and more streamlined for bringing perpetrators to justice. I cannot emphasize enough how messy and contradictory our code has been, and how difficult that has made the jobs of our judges and the judicial branch. I strongly support the slower phase-in of jury trials too, and can confirm for public the need to use this gradual approach to be attentive to the enormity of the work that will be placed on our courts and justice officials if we take on too much change at once. And we will continue to monitor as this process goes on and continue to be vigilant of staffing up and ensuring vacancies are filled. In adopting this provision of the code, the city must now be unified in demanding our federal partners support us by filling our benches with qualified and fair-minded judges. So thank you to Councilmember Allen for drafting our council letter calling for swift appointments to expand the capacity of our court system. I also want to thank you, Chairman Mendelson, for your vision your vision more than 15 years ago as Judiciary Chair to create a criminal code revision commission to bring in experts to thoughtfully and thoroughly advise the city on such important undertaking. Thank you for keeping this work on track these many years. Our city also owes you a debt of gratitude for your perseverance and transformative forward thinking in that respect. And most especially, I want to extend my deep gratitude to the staff, leadership, and members of the Criminal Code Revision Commission for your years of service and detailed, thorough work. Of course, not everyone is going to agree about every word of a 400-page bill, but your collective work product have brought this city into the 21st century, and we will be a safer, stronger, and more just city for years to come because of your work. And to all the public witnesses and criminal justice experts who testified and advised the commission over the years, thank you as well. This has been radically inclusive, transparent, and thoughtful process for overhauling our criminal code. And I'm so proud of my colleagues in our city. And I think that together, the judicial branch, the executive branch, and the legislative branch, moving forward, the city will be better because of this. And as always, we will continue to work to make things better, as Councilmember Henderson said, and be nimble and making sure we make changes as we need them. So thank you.
Thank you, Councilmember. Councilmember Silverman.
Yes, I am speaking up just to thank Councilmember Allen and the Judiciary Committee for, I think, a major accomplishment. A tremendous amount of work went into this. And I think we all need to recognize that and praise you for it. It has not been an easy task to negotiate with all of the parties involved. So thank you, Councilmember Allen, a significant achievement of yours. And this council will be and city will be the better for it. Thank you.
Thank you, Councilmember. If there's no further discussion, the vote will be on Bill 24-416, the Revised Criminal Code Act. This is final reading. Madam Secretary, would you call the roll?
Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George. You're muted, Councilmember.
You're still muted.
Try pressing and holding the space bar. Let's see if that works.
Yes.
There we go. Thank you. Councilmember Lewis George votes yes.
Okay, great.
Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Excuse me 1 second. Random barking. Councilmember Robert White votes yes. Councilmember Trayan White.
Yes.
Councilmember Trayan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The bill is approved unanimously. We have first reading on Bill 24-996, Senior Nutrition, Health, and Wellbeing Act of 2022. This bill was reported out through the Committee of the Whole earlier today. And Councilmember Bonds has an amendment. Councilmember Bonds.
Thank you. Thank you, Chairman. I do have an amendment, and the amendment really is designed to address the concerns that the Department on Aging and Community Living expressed. The committee print language requires the department to collect data on the vacancy rates of assisted living and nursing home facilities at the time of each referral. Because the occupancy and vacancy rate of these facilities changes frequently, sometimes even daily, the department felt that this requirement was overly burdensome. Despite the department's concerns, collecting this data is important for determining if there is a need for additional assistance living and nursing facilities in the district. And this amendment removes the requirement to collect the data at the time of each referral and instead requires the department to conduct a quarterly census of the occupancy and vacancy rate of all assisted living and nursing home facilities in the district. By allowing the department to collect this data all at once instead of continuously throughout the year, this amendment will streamline implementation of this reporting requirement. So move, Chairman.
Implicit is you move the bill, and we have the amendment. Is there discussion on the amendment? If there's no objection, the amendment will be accepted. Is there objection? The amendment is accepted. We have the bill as amended. Is there discussion? Madam Secretary, will you call the roll? The vote is on Bill 24-996.
Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The bill is approved first reading unanimously. We will turn now to emergency bills. The first is DC Nursing Education Enhancement Program Emergency Declaration Resolution 2022, PR 24-1042. Councilmember Silverman.
Yes, thank you. Our city needs nurses. We need healthcare professionals of all types. Nursing facilities, assisted living facilities, home healthcare agencies have long faced challenges in recruiting and retaining qualified healthcare workers. And we should be concerned about this, right? If we are going to have a city that ages in place, we need to have healthcare professionals who can help our moms and dads do that. The COVID-19 health emergency accelerated this shortage of healthcare workers, as we all know, and it has made it difficult for employers to find and keep qualified workers. And I know everyone's busy, but next time you have to go to the hospital, you're going to feel it with long waits in the waiting room. So last year, in response to this demand for healthcare professionals, I established and funded the DC Nurse Education Enhancement Program. Program participants work toward nursing degrees and nursing care certifications, such as the CNA, Certified Nursing Assistant, home healthcare aide, medication aide, certified registered nurse, and licensed practical nurse, an LPN. This program provides tuition assistance for students enrolled in courses at the University of the District of Columbia Community College and for students pursuing a bachelor's degree as part of a registered nurse to Bachelor's of Science in Nursing degree. Students within the UDC Workforce Development and Lifelong Learning Division do not pay tuition. Therefore, the program provides students a stipend for living and transportation expenses. We have been working with UDC on the rollout And in the 21-22 school year, UDC Community College enrolled 75 students. During this first year, staff learned that while many students' tuition was already paid through federal Pell Grants, many of the students struggle with paying for transportation to and from their classes and purchasing food while on campus. Students struggling with these things, as we know, will then struggle to study. So it's important to provide students with the resources they need so that they can focus on their studies and become healthcare professionals. What does this legislation do? Today's emergency provides UDC with the flexibility to meet program participants' needs by providing stipends to program participants within the community college. I encourage my colleagues to support this emergency so that we can increase the number of healthcare professionals in our city. Thank you, Mr. Chairman.
Thank you, Councilmember Silverman. We have the declaration before us. Is there discussion? Councilmember Bonds.
Thank you very much. And a question to Councilmember Silverman. I want to make sure that I heard you correctly. I think you said home care aides are one of the healthcare professionals that would be eligible for this tuition assistance.
That is correct.
Thank you. Thank you very much.
Thank you, Councilmember Bonds. Is there any further discussion? The vote will be on the declaration PR 24-1042. Madam Secretary, would you please call the roll?
Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White. Councilmember Trayon White.
Yeah.
Your audio is back. I will check with you offline. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes. Can you hear me?
Councilmember Gray votes yes. And Councilmember White, yes, we can hear you. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Mr. Chairman, there are 13.
Yes. Yes. Yes.
Thank you. Now, Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. I believe Councilmember Trayon White voted yes 3 times. We'll count them once. Your connection was a little off and on, but we got you. Thank you. Madam Secretary, you said 13-0.
Yes, Mr. Chairman.
The declaration is approved unanimously. We have the underlying bill, Bill 24-1097. Councilmember Silverman.
I move the underlying bill at this time, Mr. Chairman.
Thank you. Is there discussion? Since the declaration was approved unanimously, we will have a voice vote on the bill. All those in favor of Bill 24-1097, say aye.
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 Are there any no votes? Madam Secretary, I don't see or hear any no votes. Do you agree?
Agreed, Mr. Chairman.
The bill is approved unanimously. The next measure is 11th Street Bridge Project Emergency Declaration Resolution of 2022, PR 24-1041. Councilmember Che.
Thank you, Mr. Chairman. Today, along with council members Allen, Trayon White, and you, Chairman Mendelson, I'm moving the 11th Street Bridge Project Emergency Act and Declaration of 2022. The 11th Street Bridge Park is a landmark project that will construct a unique elevated park on the piers and foundations of the old 11th Street Bridge spanning the Anacostia River. The new park will be a venue for healthy recreation, environmental education, and the arts, The park also has the potential to positively affect the river, bringing new life to the waterfront and exposing residents to the unsurpassed beauty of this critical natural resource. This project also has received national acclaim for its equitable development and anti-displacement plans. The Bridge Park is nearing final design, and permitting has raised significant funds both from the public and private sectors and including the work of the council to expedite and increase funding in the 23 budget. One of the final steps before construction can begin is for the project team to obtain a federal Clean Water Act permit from the Army Corps of Engineers. However, this cannot be issued until DOEE first issues a Clean Water Act Section 401 certification. One of our regulatory requirements to receive this certification is that where a given amenity is not water-based, say, for example, a running track within the park, the project team must consider whether the amenity could be located on a non-water-based site and show that there are no suitable alternatives. Although recreation, education, and the arts could feasibly happen in other locations, moving them from the Bridge Park would undermine the goals of the project. This is a feature of the project intended to draw residents to the river and activate the waterway. Nevertheless, this regulatory requirement could prevent this project from moving forward. These emergency measures would address that issue by narrowly exempting the Bridge Park project from DOEE's regulations requiring that the project demonstrate that there are no feasible non-water located alternative sites for particular amenities and other intended uses of the park. And I want to be very clear about something. This 11th Street Bridge project is unique in that the project will only deliver the aforementioned benefits to the district if constructed as planned over the river, reusing the already existing piers of the old bridge. It will unite these communities in a way that is also unique. I cannot imagine many other projects that would rise to the same level or that could reuse existing infrastructure. It's because of those unique factors that I and my colleagues are moving these emergency measures today. This action, however, should absolutely not be seen as an invitation for further non-water focused development over our waterways, where those projects would not comport with DOEE's regulation. One more moment, please.
Without objection.
And I want the record to be very clear here that this is, again, a unique project, not opening the door to any other possible applications of what we're doing today. Carving out exemptions from our established environmental protections is not something I take lightly, and it should be done rarely and only upon a showing of great cause. This is one of those exceptions. Again, given the unique and meaningful benefits provided to the district by this project, the fact that it's built on existing bridge piers and foundation, that it's effectively therefore a reuse of the existing structures, an exemption is in the best interest of the district. And again, I cannot imagine any other project that would meet these requirements. So I move the emergency declaration.
Thank you, Councilmember Che. We have the declaration before us. Is there discussion?
Yes, Chairman.
Councilmember Trahan White.
Yes, thank you. I want to express my thankfulness to Councilmember Che and all those who are involved in the 11th Street Bridge project, Scott Kratz and his team, and just the advocates and ensuring that we can create a new look for the city. This park, over a decade in making, creates so many opportunities for equitable investment and development. And I will remain committed to ensuring that we have equity and inclusion at every phase. The resident of Ward 8 deserve innovation, exemplary outdoor space, and the literal and symbolic significance of this pedestrian bridge. It is not lost on me. I'm so excited about the future of this project. It also launched the Douglas Community Land Trust to allow for more people to own homes that are affordability rates here in the district and here in Ward 8. I'm proud to have co-introduced this. I look forward to seeing this to the finish line, and also ensuring that residents feel like this is a part of our community, that we can be inclusive and be the driving force in this as we bring it to fruition. So I want to thank you again, Councilmember Che, and the other members who voted and support this legislation. Thank you.
Thank you, Councilmember. Further discussion? We have the declaration before us. It's PR 24-1041. Madam Secretary, would you call the roll?
Councilmember McDuffie?
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto?
Sorry.
Councilmember Pinto?
Yes.
Councilmember Pinto votes yes. Councilmember Silverman?
Yes.
Councilmember Silverman votes yes. Councilmember Robert White?
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White?
Yes.
Councilmember Trayon White votes yes. Councilmember Allen?
Yes.
Councilmember Allen votes yes. Councilmember Bonds?
Yes.
Councilmember Bonds votes yes. Councilmember Che?
Yes.
Councilmember Che votes yes. Councilmember Gray?
Yes.
Councilmember Gray votes yes. Councilmember Henderson?
Yes.
Councilmember Henderson votes yes. And Councilmember Lewis George?
Yes.
Councilmember Lewis George votes yes. Mr. Chairman, there are 13 yeses.
The declaration is approved unanimously. We have the underlying bill, Bill 24-1095. Councilmember Che.
So move.
Is there discussion? The vote will be on Bill 24-1095. Since the declaration was approved unanimously, we'll do a voice vote. All those in favor of Bill 24-1095 say aye.
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 Are there any no votes? Secretary, I don't see or hear any no votes. Do you agree?
Agreed, Mr. Chairman.
The bill is approved unanimously. PR 24-1045. The Small Business Relief Grant Program Emergency Declaration Resolution of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. As part of the fiscal year 2023 budget, the council approved an $8 million allocation to the Office of the Deputy Mayor for Planning and Economic Development to support the district's Small Business Relief Grant Program, also known as the Bridge Fund. As in prior years, DMPIT plans to partner with a third-party grant-making entity to manage the Small Business Relief Grant Program. DMPIT's current grant-making authority allows for up to 2% of funding for the Small Business Relief Grant Program to be used to cover administrative costs associated with administering the grant program. Also, as part of the FY23 budget process, the Committee on Business and Economic Development amended the grant programs authorizing legislation to allow sole proprietors and home-based businesses to participate alongside traditional brick and mortar establishments to broaden the type of small businesses that would be eligible to receive funding. Experience from prior grant cycles indicates that businesses require extensive assistance to be grant ready, and a substantial amount of effort is required to review applications, determine awards, and ensure compliance with grant requirements after award. Because dedicating 2% of funds to cover administrative costs is not sufficient to cover the amount of work that's going to be required to administer these grant funds, this measure increases the cap on the administrative costs to 7%. This emergency measure is necessary to ensure that DMPIT can select a grant administrator and launch the Small Business Relief Grant Program in a timely manner this fall. With that, I move the declaration.
Thank you, Councilmember. We have the declaration before us. Is there discussion? The vote will be on PR 24-1045. Madam Secretary, would you call the roll?
Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto?
Yes.
Councilmember Pinto votes yes. Councilmember Silverman?
Yes.
Councilmember Silverman votes yes. Councilmember Robert White?
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White?
Yes.
Councilmember Trayon White votes yes. Councilmember Allen?
Yes.
Councilmember Allen votes yes. Councilmember Bonds?
Yes.
Councilmember Bonds votes yes. Councilmember Che?
Yes.
Councilmember Che votes yes. Councilmember Gray?
Yes.
Councilmember Gray votes yes. Councilmember Henderson?
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George?
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie?
Councilmember
Councilmember McDuffie votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 24-1104. Councilmember McDuffie.
So move.
Is there discussion? Since the declaration was approved unanimously, we'll do a voice vote on the bill. The vote is on Bill 24-1104. All those in favor say aye. Aye.
Aye.
Are there any no votes? Madam Secretary, I don't see or hear any no votes. Do you agree?
Agreed, Mr. Chairman.
Bills approved unanimously. We have three temporary bills. DC Nursing Education Enhancement Program Temporary Amendment Act, 11th Street Bridge Project Temporary Act, and the Small Business Relief Grant Program Temporary Amendment Act. There's no objection. We'll consider them in block. I'll say so moved. Is there any objection? I know the secretary loves it. We do one last roll call vote, keeps her in practice. The vote will be on the three temporary bills that are on the agenda. Madam Secretary, would you call the roll?
Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Mr. Chairman, there are 13 yeses.
The three temporary bills are approved unanimously. That's going to conclude the business for this meeting. Our next legislative meeting is a regular meeting on December 6, 2022, starting at 12 p.m., except that there will be a committee of the whole first. I do want to warn members, and I should have said this earlier, because December 6th is the penultimate legislative meeting of Council Period 24, I expect that there could be quite a long agenda. And it is probable that we will start before 12 o'clock for Committee of the Whole. That does not mean, Councilmember Henderson, that we will get out early. It just means that we won't be getting out as late. But there also will be a legislative breakfast. So we'll have to sort of move along to handle all the measures. The time is now 3:46 p.m. and this meeting is adjourned.